So there's big news about denaturalizations in the United States. Based on recently leaked documents, USCIS has been instructed to refer 100 to 200 cases per month to the Department of Justice to consider denaturalizing people, or naturalized US citizens more specifically. Now, this is a massive uptick because generally the historic average of denaturalizations in the US has been 15 per year. And if the documents leaked actually become truth, well, we would be going from 15 a year to 100, 200 per month. So we'd be going from 15 to over 1,000 a year. Now, so many of you have reached out to me with questions about this because I used to work at the Department of Justice Office of Immigration Litigation, which handles denaturalizations for the US government. So in this video, I'm going to go over my thoughts and just sort of important considerations about this because I know so many people are worried, and I hope to ease some fears that all of you may have. If you're new to the channel, my name is Adrian Pandev. I'm an attorney who helps foreign nationals navigate the US legal system. I used to work, like I said, at the Department of Justice Office of Immigration Litigation, which handles denaturalization cases. So I hope I should be able to comment on this topic. If you like the content and want to receive the updates when I post new videos, please subscribe to the channel and like the video. That helps me tremendously and will help you get updated. Now, before I go any further about denaturalizations, you should note that I have several other videos explaining how it works, the high standard, how the government processes these cases, etc., that I have recorded previously. So if this is the first time you're hearing me talk about denaturalizations, I recommend you watch those videos, because in this video, I'm not going to go over how the process works and my general thoughts about it. I'm going to focus on these recently leaked documents as of December of 2025. So while I completely understand the concern about this, essentially it's a 16,000% increase if we were to go from 15 a year to over 100 a month. But there's some very important considerations that I want to explain in this video. So first and foremost, the denaturalization cases, right, are brought by the Department of Justice, and they're filed in federal court, where there's a very high standard, which I explained in previous videos, that the government, the Department of Justice, has to prove in order for a federal judge to agree and actually denaturalize someone. So why is this important? Well, it's important because it means that both the Department of Justice and federal courts have to be able to handle this massive amount of cases. Now, keep in mind, federal courts are busy. There's many cases in federal courts. Many of the judges may not be sympathetic to these arguments, especially if they're weaker cases. All the judges are lifetime appointees, so they enjoy a high level of neutrality compared to, say, immigration court or other administrative immigration tribunals. So the first thing is to keep in mind is the federal courts. The second one is the Office of Immigration Litigation itself, that handles these cases on behalf of the government. That's also a busy office, right? They represent the government, and when someone files a mandamus petition, essentially arguing that the USCIS or other immigration agency is taking too long with the case and not adjudicating them in a reasonable time. They represent the government in challenges to agency decisions. So essentially, if people arguing that the government has made an error in deciding their immigration case, they also represent the government in appeals cases. So essentially, if someone wants to appeal their case in immigration court, it goes up to the Board of Immigration Appeals, and from there to the federal appeals courts, and the Office of Immigration Litigation handles those as well. So it's a busy office, right? And adding this volume of cases, essentially asking them to go from 15 to over 15 a year to well over 1,000 a year is a tremendous ask, unless the pool of attorneys working there and just everything is expanded tremendously as well. Another very important point to note is that the leaked documents talk about referrals to the Department of Justice. So essentially, USCIS a quota has been placed on USCIS to refer these cases to the Department of Justice. But the Department of Justice doesn't have to actually proceed with these cases. So just because they're being referred is not the same as actually the government filing denaturalization cases against over 100 people a month. It just means that information about potential cases about that the government should consider denaturalizing will transfer to the Department of Justice, and then the Department of Justice will be able to decide with which ones to proceed. It is presumably likely that they're not going to initiate every single one of those cases. So essentially, it could just mean that there'll be an uptick of cases that the Department of Justice will be aware about, and then the Department of Justice can decide whether or not to proceed, or with which cases to proceed and which ones they think are worth actually pursuing. So the final number of denaturalization cases could be significantly lower than the amount that's being transferred, and it's only the amount being transferred on which the government has put this quota of 100 to 200 a month. And given that the standard is so high, as I explained in previous videos, the government bears a very high burden of proving that the individual essentially committed fraud or materially misrepresented and illegally procured their U.S. citizenship. It's likely that the Department of Justice is going to not file cases that they know that will be immediately struck down by federal judges that historically have not denaturalized people unless these super high bars were met. Now, another thing to keep in mind here that I think is important as well is when you look at the totality of cases, right, naturalization cases, about 800 to 900,000 people get naturalized in the U.S. each year. So when you look at, let's just go with 1,500 people a year, right, sort of the middle of this 100 to 200 cases that's being referred, we're still talking about a minuscule amount of cases. So we're talking well less than 1% of cases. So when you look at out of all those cases, how many could actually have material misrepresentations and fraud, etc., that very small percentage statistically may actually have major issues. So the reason I'm saying this is that every one of you that's reached out to me to ask about denaturalization asked about very, very minor things. There are probably that percentage amount of cases that have very major issues, such as major criminal convictions that were not disclosed, or other major security issues and other major violations that were just not disclosed to the government. So I do think it's important to keep the amount of naturalizations versus the amount of cases we're talking about here in mind, because it's a fractional percentage. I think the biggest concern with placing quotas on an agency and telling USCIS that every month you have to refer this many is that the focus is not on make sure bad guys who've committed awful violations, have done awful things in the past and somehow became U.S. citizens are referred to the Department of Justice. And I think most would agree that people who've done truly awful things and then lied about them should be denaturalized and shouldn't be U.S. citizens. Instead of keeping the focus there, by putting a quota on it, the focus is more on numbers, right? Just refer this many cases each month. So when the focus is on numbers, often it's easier to locate cases where the individuals haven't done something awful in the past, but it's more minor convictions or minor violations that remained undisclosed. And I think that is what's concerning, at least to me, about the quota system. But again, I go back to the high standards in court and the amount of cases where even if USCIS refers these call it lower hanging fruit cases to Department of Justice, that doesn't mean that the Department of Justice will feel that they meet this threshold and will actually initiate denaturalization proceedings, and that federal judges will actually agree with those arguments even if they're brought. So anyway, those are my thoughts on all of this. Thank you so much for tuning in, and have a wonderful day. Bye-bye.